it's Jen again, and this time I want to talk about the difference between the natural person and the legal person, and hopefully shed some light on the issue. I have here a birth certificate for a child born in state of Texas, and this is the parent worksheet for child's birth certificate VS 109.1. You'll have to check your state's documents to see what theirs says. But in this one, it's pretty obvious. It starts off with the birth certificate is a legal document. Okay, now I'm going to distinguish between what is a legal document and what's not a legal document, or hopefully you'll just understand it by the time I'm finished. The state of Texas is a legal entity, it's a subject matter, and it's not the same as being um, part of the geography. It's not part of the land, okay? It's subject matter. Down here, you see parent one, the current legal name. So if I were going to do my children's birth certificates again, I would put none right here. Child's legal name, I would also put none. And child's place of birth, I assume you could probably figure this out, but I would put private. Okay, child's information, I would also put private. Legal name is not private, so I would put none and none. That's just what I would do. Okay, I'm just talking in hindsight. I'm not ever telling anybody else what they should do. People need to decide for themselves. Okay, so I go to this book. This is Jurisprudence by John Salmon. And I have a fourth edition, and I'm not sure which edition this is, but I found it on the internet under something called Musicians for Freedom. And I was looking for the fourth edition, but this one came up and it works pretty good. It's a good edition. So this is the book, and some of these writings by these lawyers and jurists, they can get kind of complicated and they go back and forth, and you're not really sure which one they mean when they say the for or the after or the. So what I did was I created this little chart here, and I put what it said about natural persons here and what it said about legal person here. But just so you know, they said a lot more about legal persons, but I didn't include all of it here. Okay, I'm just trying to give you an idea about things. So the natural person is in fact and real, not juristic. May have, this is probably a mistake on my part because it said that the legal fiction has rights, duties, such as those under oath, but it didn't say no rights or duties. As a matter of fact, it said that property had no rights or duties, but you'll see that when I read through some of these pages. And I'm only going to read a few things. Okay, is a man or a human being? These are gods, angels, the dead, corporations, myths, real or imaginary, but they're created by men. So men create the legal fictions, but men are not the legal fictions. Okay? And the legal fictions cannot be men. So legal fictions cannot be treated as if they were men. They can only be treated as legal fictions. Okay? So all are persons and are persons. So both are persons. Natural person has a personality in accordance with reality and truth. These are joint stock companies, municipal corporations, and legal contemplation. So that's a phrase you may want to look up if you want to do more research on it. Not a fictitious man, italicized in the book, has personality but is not human nature. So it doesn't conform to human nature. Natural people conform to human nature. Personality does not. Our body's corporate. Body's corporate possesses judicial significance and thus receives legal recognition. Personality by way of fiction when there is no person in fact. These are persons in fact. Natural persons are persons in fact. So it's saying it's a person, but not a person in fact, because it's a fiction. If it's a fiction, it cannot be in fact. Persons in law, but not in fact. Arbitrary creations of the law are of any kind. And then it had three classes of persons. And I've read in other books that only classes can be controlled by the government. So you have the first class, which are corporations and members. Members being those who take an oath, who are members of the body politic. Maybe they're voters too. I'm not sure about that. But I know that it's at the least Congress and the president, because Congress and the president are required to be citizens of the United States, which is a political subdivision. Okay, now it's interesting that the judicial branch is not required to be a citizen of the United States. The second class, the institutions, churches, hospitals, universities, libraries, aggregate human beings such as chancellors, vice chancellors, fellows, and graduates of the institutions. So the third class, which it actually didn't use class in the book, it used kind. So funds, estates, charitable funds, trust estates, property of a dead man, and bankrupt. So I was thinking, I could take all of my legal fiction and hand it over to my natural person. And perhaps that would make a difference to whether or not any of my property or equity could be leaned on by any legal corporation. But I don't know yet. I have to give it some more thought. So we're going to scroll down to page 334. It's 334 on the book. Of course, we know the PDF pages are a little different. So this PDF page 358, but it's on the book, it's 334. So it's chapter 15, persons, the nature of personality. Now, I suggest you read through chapter 15. It's not that long. I'll scroll through it real quick. It gives a nice little summary at the end in a kind of a graph form. I hope you're not sitting there going, oh my God, it's so long, because this is really nothing compared to the length of the entire book, which is 754 pages. So we're down to 367. So roughly about 33 pages or so. Okay, so there's only a few sections in here that I'm going to read just to entice you enough to maybe go out and look for the book and read some of this in chapter 15 for yourself. So this is section 109. The fourth edition that I have is a little bit different, so you can look for the fourth edition if you want. It's I like the fourth edition, I think, better than this one. But this in section 109 says the nature of personality. The purpose of this chapter is to investigate the legal conception. Okay, this is a conception. This is an idea. It's a legal idea of personality. It's not proven because it's all fiction and theory. Most things in law are theory. Okay, so let's keep that in mind. Also, this guy who wrote this book wrote it based on the laws of England. Basically, at the core, all laws are pretty much the same in most countries. They differ a little depending on the type of government they have. So these laws in the United States of America may be a tad bit different, but basically it's the same. So it says it is not permissible to adopt the simple device of saying that a person means a human being. So it's saying a person is not simply just a human being. For even in the popular or non-legal use of the term, there are persons who are not men. So even outside of legal conception, contemplation, or theory, persons, the word persons can be used to signify those who are not actual living human beings. They could be angels, gods, or myths, any kind of other fiction that is in nature. So personality is a wider and vaguer term than humanity. Gods, angels, and the spirits of the dead are persons no less than men are. And in the law, this want of coincidence between the class of persons and that of human beings is still more marked. In the law, there may be men who are not persons. Slaves, for example, are destitute of legal personality. in any system which regards them as incapable of either rights or liabilities. Like cattle, they are things and the objects of rights, not persons and the subjects of them. Conversely, there are, in the law, persons who are not men. A joint stock company or a municipal corporation is a person in legal contemplation. It is true that it is only a fictitious, not a real person, but it is not a fictitious man. It is a personality, not human nature, that is fictitiously attributed to the law to bodies corporate. So far as legal theory is concerned, legal theory, a person is any being whom the law regards as capable of rights or duties. Any being that is not, that is so capable, I'm sorry, let me start that sentence again. Any being that is so capable is a person, whether a human being or not. No being that is not so capable is a person, even though he be a man. Persons are the substances of which rights and duties are attributes. It is only in this respect that persons possess judicial or juridical significance, and this is the exclusive point of view from which personality receives legal recognition. But we may go one step further than this in the analysis. No being is capable of rights unless also capable of interests, which may be affected by the acts of others. For every right involves an underlying interest of this nature. Similarly, no being is capable of duties unless also capable of acts by which the interests of others may be affected. To attribute rights and duties, therefore, is to attribute interests and acts as their necessary basis. A person, then, may be defined for the purposes of the law as any being to whom the law attributes a capability of interests and therefore of rights, of acts and therefore of duties. So when Congress members take an oath, they have an interest to the acts, rights, and duties, okay, because they have an oath to the Constitution, therefore they're members. And if they're members of a body politic, then they would be a legal person. Persons, as so defined, are of two kinds, distinguishable as natural and legal. A natural person is a being to whom the law attributes personality in accordance with reality and truth. Legal persons are beings, real or imaginary, to whom the law attributes personality by way of fiction, when there is none in fact. Natural persons are persons in fact as well as in law. Legal persons are persons in law, but not in fact. Okay, so legal persons are fictions in law, but they're not real, whereas natural persons are in fact real and also in law. Okay, so it can go one way and not the other. And I believe this is why Trump signed the order that said that people involved or members of the government involved in the election, FRAUD, uh, could have their property confiscated because they acquired that property through illegitimate use of their legal person and their office. So if you have no legal person and you're not a member of Congress, the things that you have that you have acquired, such as your property, is your property in fact belonging to your natural person because you have no legal fiction. Okay, you only need a legal fiction, such as the one that is created by the birth certificate, when you want to go over there and work in that stuff. Okay, the government or contracts, or you want to start a big corporation, which can be controlled by the government. So they say. Okay, so then it goes on to section 110, the legal status of the lower animals. And I'm not going to read that. And then it goes into the legal status of dead men. It goes into legal status of unborn persons. So it says the unborn persons can be heirs. Okay, so even you know, if he's not born, he would still be a legitimate heir, providing he is born and born alive. Then we get down to this interesting thing, which is section 113, double personality. Okay, so it often happens that a single human being possesses a double personality. He is one man but two persons, unus homo. He is said duas personas sustinet. Sustinet. Okay, I don't speak Latin. In one capacity or in one right, as English lawyers say, he may have legal relations with himself in his other capacity or right. He may contract with himself or owe money to himself or transfer property to himself. So some of these rich people, these elite, these bankers, Rockefeller, Rothschilds, and stuff, they don't bank with their banks. They don't bank with other banks. What they do is they save their money, they keep it somewhere safe and private, and when they want money, they go to themselves and get money from themselves to buy what they want and then pay themselves back with interest. And that's how they keep their money, because they don't go to banks and ask for loans and pay interest. And that's something I've read in other books, and I have a video on that there by James E. Hughes. If you want to look up that video, I explain stuff in there. Okay, so the double personality exists chiefly in the case of trusteeship. A trustee is, as we have seen, a person in whom the property of another is nominally vested. So your children, you're the trustee of your children. Okay, and that's through God, it's not through any legal paperwork. To the intent that he may represent that other in the management and protection of it. So your children depend on you for their management and protection, right? And for you to represent them. A trustee, therefore, is for many purposes two persons in the eye of the law. In right of his beneficiary, he is one person, and in his own right, he is another. In the one capacity, he may owe money to himself in the other. Okay, so that's what I told you about, like these rich people that they have trusts and they keep their money outside of the banks and they loan money to themselves or they loan money to their family members. So they don't ever have to go to the bank like us, deplorables do. In the one capacity, he may own an encumbrance over property which belongs to himself in the other. So maybe you have two natural persons, or maybe you have a natural person and a legal person, and your legal person owes money to your natural person. And your natural person holds all the property. So your legal person, if they don't pay you back, they just lose out, I guess. So there's no recourse really. It's sort of a system set up to make sure that some people always win, I think. I think that's why this was set up. Because, when corporations go bankrupt, they just go to court and file bankruptcy. And here we have our federal government bailing them all out. They never lose. There's no repercussions for their bad choices or decisions because they have a legal person. And once they make that profit, they hand it over to their natural person. And I promise you, their natural person is not paying taxes. He may be his own creditor or his own landlord, and where a testator appoints one of his creditors as his executor or makes one of his tenants the trustee of his land. In all such cases, were it not for the recognition of double personality, the obligation or encumbrance would be destroyed by merger, or confusio, as the Romans called it, for two persons at least are requisite for the existence of a legal relation. No man can in his own right be under any obligation to himself or own any encumbrance over his own property. Nulli res sua servit. Okay, so legal persons. A legal person is any subject matter. Okay, it's personality, but it's subject matter. It's not quite human being. to which the law attributes a merely legal or fictitious personality. This extension for good and sufficient reasons of the conception of personality beyond the limits of fact. This recognition of persons who are not men is one of the most noteworthy feats of the legal imagination. You see that? Legal imagination. That's theory, contemplation of the law. Okay? And the true nature and uses of it will form the subject of our consideration during the remainder of this chapter. They call it something, some metaphor, a mere metaphor. Okay, so we need to pay attention to these things: legal imagination, contemplation of the law, legal fiction, a metaphor, the animus of a fictitious personality. Those are important things that you need to understand when you're looking at the legal person. Just, when you go to court, if you ever happen to go to court, you can ask them, is this, are you asking about a person in someone's legal imagination, or a metaphor? Are you looking for the metaphor? You're looking for the person contemplation in law. So, just some things to think about. Okay. The law, in creating legal persons, always does so by personifying some real thing. So they pretend like you're it. They're personifying you as a legal fiction. Such a person has to this extent a real existence, and it is his personality alone that is fictitious. There is indeed no theoretical necessity for this, since the law might, if it so pleased, attribute the quality of personality to a purely imaginary being. You see that? Attribute the quality of a personality to a purely imaginary being, and yet attain the ends for which this fictitious extension of personality is devised. Personification, however, conduces so greatly to implicity of thought and speech that its aid is invariably accepted. The thing personified may be termed the body of the legal person so created, or that's corpus. Body is corpus. It is the body into which the law infuses the animus of a fictitious personality. Although all fictions are legal personality, Although all fictitious or legal personalities involves personification, the converse is not true. Personification in itself is a mere metaphor, not a legal fiction. Legal personality is a definite legal conception. Personification, as such, is a mere artifice of speech devised for compendious expression. In popular language and in legal language also, when strictness of speech is not called for, the device of personification is extensively used. We speak of the estate of a deceased person as if it were itself a person. We say that it owes debts, or has debts owing to it, or is insolvent. The law, however, recognizes no legal personality in such a case. The rights and liabilities of a dead man devolve upon his heirs, executors, and administrators, not upon any fictitious person known as his estate. Similarly, we speak of a piece of land as entitled to a servitude, such as a right of way over another piece. So, also, in the case of common interests and actions, we personify as a single person the group of individuals concerned, even though the law recognizes no body corporate. We speak of a firm as a person distinct from the individual partners. We speak of a jury, a bench of judges, a public meeting, the community itself, as being itself a person instead of merely a group or society of persons. But legal personality is not reached until the law recognizes over and above the associated individuals a fictitious being which, in a manner, represents them but is not identical with them. Legal persons, being the arbitrary creations of the law, may be of as many kinds as the law pleases. Those which are actually recognized by our own system, however, all fall within a single class, namely corporations or body corporate. A corporation is a group or series of persons which by a legal fiction is regarded and treated as itself a person. If, however, we take account of other systems than our own, we find that the conception of legal personality is not so limited in its application, and that there are at least three distinct varieties. They are distinguished by reference to the different kinds of things which the law selects for personification. And here are the classes I told you about. 1. The first class of legal persons consists of corporations as already defined, namely those which are constituted by the personification of groups or series of individuals. The individuals who thus form the corpus of the legal person are termed its members. We shall consider this form of fictitious personality more particularly in the sequel. 2. The second class is that in which the corpus or object selected for personification is not a group or series of persons, but an institution. The law may, if it pleases, regard a church or a hospital or a university or a library as a person. That is to say, it may attribute personality not to any group of persons connected with the institution, but to the institution itself. Our own law does not, indeed, so deal with the matter. The person known to the law of England as the University of London is not the institution that goes by that name, but a personified and incorporated aggregate of human beings, namely the Chancellor, Vice Chancellor, Fellows, and graduates. It is well to remember, however, that notwithstanding this tradition and practice of English law, fictitious personality is not limited by any logical necessity or, indeed, by any obvious requirement of expediency to the incorporation of bodies of individual persons. The third kind of legal person is that in which the corpus is the fund or the estate devoted to special uses, a charitable fund, for example, or a trust estate, or the property of a dead man or of a bankrupt. Here also English law prefers the process of incorporation if it chooses to personify at all. If it chooses to personify at all, it personifies not the fund or the estate, but the body of persons who administer it. Yet the other way is equally possible and may be equally expedient. The choice of the corpus into which the law shall breathe the breath of a fictitious personality is a matter of form rather than of substance, of lucid and compendious expression rather than of legal principle. So you have a choice in whether or not you personify in the law. If you do, then you're talking about your fiction, a metaphor, something in contemplation of the law, an artificial being clothed with personality and not with actual human nature, not a man, but has a man so that you can contract with yourself, etc., etc., etc. So this again is jurisprudence. I love reading about jurisprudence. I really geek out on this stuff. And this is Or the Theory of the Law, John Salmon. Okay, this is the 1902 edition. The fourth edition I have, I'm not sure which year it is. Okay, so how do you do away with this? How do you end the legal fiction? I do not know. If anybody knows, or could point me into a direction or give me a book to read, I will read it and then I will make videos on it. And I would appreciate any help out anybody can offer. This is my help to you. And please share it and look into maybe contemplating whether or not you really want to have a legal fiction. Thanks a lot for listening.